points that we were going to make, but the others aren't so important.
Okay, thank you. And in your debate with Justice Mhlanhla, you said that even if, for instance, I'm asking this, let's leave the facts of this matter aside.
Yes.
Let's say there's a genuine application. This person came to South Africa and not as an asylum seeker, right? And then in the process of them being here, they then learn that things are bad in their country. And you're saying that if that person had applied and his application had been refused, he would still not qualify, even if it's a genuine application.
Yes, on the statute as it sits currently, Justice, because what I was trying to distinguish is a first-time applicant, which could be a surplus refugee or a person who was fleeing persecution, and a reapplication. And so the statute doesn't allow the third category, which is a reapplication. It does allow surplus and ordinary first-time applicants. And so even if there's a genuine change in circumstance, the statute on our reading currently doesn't give you that right. The only way one could get to that is to bring a necessary constitutional challenge to say the Act fails in the following regard. It should actually say this, it doesn't. But one can't achieve that outcome through a mandamus application.
You've also said that the SCA arrived at a decision and made an order against you because it looked at international law.
No, it looked at foreign case law.
At the foreign cases.
Yes, indeed.
All right.
So its judgment sets out the principles. It starts off by the principles of non-refoulement. It looks at the AU Convention, the Refugee Convention, etc. And then it says, we don't have any case law or laws that deal with this particular question. And to answer that, relying on Section 39(2) of the Constitution, it then engaged in that foreign law analysis. But the problem is that, it's statutes from another country, not this particular Refugee Act.
Let's look at paragraph 80 of the SCA judgment.
I have that.
Am I wrong to say that they seem to be saying because there's change in circumstances and there are new facts, that is why you have to reconsider the application?
Yes, that is indeed what the court says at paragraph 80, yes.
So basically, they are not saying simply because the situation is like this in other countries, then you must do it. They say that in this matter, it is because of new facts that you must consider the application.
No, Justice Mhlanhla. So that paragraph 80 is the conclusion of its analysis of the foreign case law, because it begins its judgment by stating that there is no law in this country that regulates the situation that we're dealing with here. And so to assist us in dealing...
You're reading from which paragraph?
Yes, if I could take the court to... in the judgment, page 482, paragraph 26. At paragraph 26, it says, South Africa has not yet developed a significant jurisprudence on surplus refugee claims. And then in Ruta, it says the court made a passing remark to this issue. This is understandable as a dispute there centered on two issues, etc. As far as we could establish, this is the first case in this court in which a surplus claim was directly asserted. Although we are not called upon to determine the merits of the application, it is important to give some guidance, as to how such claims should be considered. And then it says at 27, given the absence of authority on this issue in our jurisprudence, it is useful to look to foreign law as permitted by Section 39(1) of 1C of the Constitution. I do so mindful, and then it sets out the test in H versus Fito.
And then page 28 then deals with the correspondent. What confused me about your submission about the reliance on the law in the other countries was because when they take a turn, because when you read this judgment,
yes,
in the main, it seems to favor you until the SCA then said, but in this case, this is the situation.
Indeed.
Yes.
So, yes, so what I'm saying is we are absolutely on all fours with the SCA about the international law obligation on non-refoulement. And we agree with the court's finding that it's not an absolute right. But then the court says, well, if there's a new case or a new fact, then you must consider the application. But what we submit is then on what basis? Because if the Act says beginning to end finality, how do you restart the process? How the SCA gets there is through that foreign case law analysis. And in our heads, we quote the laws of these respective countries that demonstrates that you can bring a reapplication, which is not present in our law. Because the court will see in the SCA's judgment, it doesn't pin to any provision of the Refugee Act that allows a fresh application as we submit.
Anyway, you're saying there are no new facts because when the respondents flee their country, there was circumstances, unbearable circumstances already.
Yes, and there's a factual dispute about whether the claim is a new basis or not between the parties. The court will see that one of the bases by the respondents is the election of the president at that time, and that he was the cause of all of that upheaval. The department's version is, well, he died shortly thereafter and there's a new president and the UN says everything is fine. But the court doesn't have to go as far as deciding the factual dispute, because if we are wrong that there is a clear right, then the court must order a mandamus and the RSDO must consider all of those particular facts. But if we're right, then the case ends there.
So you agree with the respondent that we should ignore the facts?
Yes, we're saying the case only turns on a question of law. The factual disputes aren't important because, as the court correctly said in Ruta, the appropriate person to make up all of those and weigh up all of those factors is actually the Refugee Status Determination Officer.
Okay, thank you. Thanks.